So what are the duties of an executor? We're going to talk about it in this video. Welcome to the Mullooly Assets Show. I'm your host, Tom Mullooly, and this is episode 341. Thanks for tuning in. So you've been named an executor. What are the duties that are involved? Well, the very first thing is you've got to find the will. You have to locate that. If it's not readily available, contact the law firm that wrote the will. They usually have a copy in their safe. The next thing you've got to do is you've got to get to the surrogate's office in the county. That's where you will get appointed as an executor and the will can be probated. If you're in Monmouth County, you're going to go to the Hall of Records. It's on East Main Street in Freehold. If you're in Ocean County, you're going to go down to the Ocean County Courthouse on Washington Street in Toms River. If you're in Mercer County, you're going to 175 South Broad Street in Trenton. You should also know that in Monmouth County, one day a month, you can see the surrogate at the Middletown Public Library. Pretty good. They also have one day a month at the Monmouth County Connection over on Route 66 in Neptune. But you need to, people ask all the time, why do I need to go to the surrogate's court? Well, when you're a surrogate, when you become the executor, you're legally appointed. You are the fiduciary for the estate. Let's not forget that. This is a legal appointment. And technically in New Jersey, little fun fact, you can't be appointed an executor until 11 days after the date of death. That's something that I learned over time. Also, the technical process is the executor applies to have the will admitted to probate, and then they ask the court to be appointed as the executor. So there's a little bit of a process involved with this. Once the will gets probated, the executor has just 60 days to kind of get their act together. They've got 60 days to notify all of the heirs and all of the beneficiaries that are named, listed in the will. So don't sit around on this. The surrogate's office is really just for straightforward estates. If you've got a surviving spouse and everything's going to the surviving spouse, easy peasy. If you've got everything detailed out, you can usually go right through the surrogate's court. However, if you have an estate where things are going to be, there's going to be some disputes or objections, or something's going to be contested, the will or the estate, you've got to go to Superior Court, the Chancery Division. So just know that in advance. Hopefully things are straightforward for you. But back to this, you can't sit around and wait on this stuff. You can't dilly-dally. If your banker or broker needs a surrogate certificate, the surrogate certificate is proof from the court that you are the executor and you are responsible for carrying out the estate matters. If your banker or broker needs a surrogate certificate, and they probably will, those certificates are usually good for 30 to 60 days, the ones with the raised seal. We had a situation not too long ago where someone produced a surrogate certificate that was a year old. Not a big deal. They just had to get back to surrogate's court and get an updated one with a raised seal on it, but just don't dilly-dally when it comes to this stuff. It's a good idea to arrange to have access to some funds when you're becoming an executor, because when you notify your bank or your broker that someone has passed away, technically they're going to freeze these accounts. They're going to put a hold on it or a block on it. You can't do any trades. You can't take money out. So that money's going to be locked up until you have the proper paperwork. So you want to have some cash available for this. You're certainly going to need a surrogate certificate. You may need a Form L8. You may need tax waivers, estate tax waivers, especially if you've got stock certificates in hand. So if you're handling an estate where they had stock certificates at home or in a safe deposit box, You're going to need tax waivers. That's when things start to get very complicated. So if you know that someone has stock certificates at home, please get them into a brokerage account. While we're on the topic, everyone's going to need a death certificate. Every bank that you deal with, death certificate. Every broker that you deal with, gonna need a death certificate. If you want to change the title on the deed, death certificate. If you want to change the title on a car, death certificate. You're gonna need more than you think. The funeral home that you're working with can really help you out with that. Just be aware of this sort of thing. You want to get a tax ID number for the estate. Go to irs.gov. It's free. You can do it online and get a number immediately. You want to set up estate accounts at your bank or broker. It doesn't have to be at the bank that this person who passed away dealt with. You can have that anywhere. You have to calculate the date of death value for all of the assets. This is a very common place for mistakes. A lot of people, for some reason, don't know how to do this. A good advisor is going to know how to calculate a date of death value for an estate. If you've got questions, definitely get in touch with us. We'd be happy to help you out. It is not simple and straightforward when it comes to being an executor. We handle these things all the time. Most people might serve as an executor once or twice in their life. Hope we can help you out.